You know?
Yes, Your Honor. They didn't clarify that, but they did.
Then too bad, so sad.
It does not say, Your Honor.
That sucks. Then write a better report.
It's not a hunch
here. I mean, it's not that hard to write in the report.
Good morning, Judge. How are you?
What's going on?
Judge, I'm here on docket for Mr. Nathan Rhea, Judge. I'm seeing if you'll revisit probable cause in this case.
You said Rhea?
Yes, sir. RHEA, Judge.
Okay. Is it on docket today?
Yes, Judge, it's my understanding.
Jail, maybe jail docket. I see. Yeah, it's jail docket.
Yes,
okay.
Sir.
All right, ready?
Yes, sir.
Go for it.
So, on December 29th, 2024, the officer observed the defendant's vehicle traveling 91 miles per hour in a 50-mile-per-hour zone.
91 in a 50, but he's already cooking and only goes downhill from here.
A traffic stop was initiated, and the officer observed the driver leaning over the console, trying to conceal something next to the console in the front passenger seat. The driver and the passenger did not see the officer as he was standing near the driver window, where the officer observed the driver have his hand between the front seat and the center console. The officer ordered the occupants out of the vehicle and observed a plastic bag containing a green leafy substance with an odor of marijuana as the front passenger exited. And the front passenger immediately took off running, and the defendant, the driver of the vehicle, stated he only knew the passenger to be named Junior. The weight of the marijuana was 0.3915 ounces.
Judge, looking at the totality of the circumstances, the state has not been able to allege enough probable cause that my client knew or intended that there was marijuana in his possession. I understand that the allegations say that there was some type of furtive movement, but my client yielded to law enforcement show of authority and then gave law enforcement his identification. The passenger ends up leaving law enforcement. He stays there. And again, there's not enough to establish that he knew or intended that there was weed in his car. The allegations also don't, pinpoint where the marijuana actually was. So this was unbeknownst to my client, Judge.
So he comes up, officer comes up with the car, and he sees him trying to conceal.
Yes.
Right?
I don't think that, I believe the allegations say that that's what the officer maybe seems to believe, but after further review, there's nothing that says that's definitive or that that's even probable cause. For all we know, he was rummaging around to give him his ID, which he did. That's why he got picked up.
No, but he says he's got a plastic bag and he's trying to put a plastic bag behind the console.
Yes, Your Honor, they found his hand between the front seat and the center console. They observed his hand in between the console.
There was a plastic bag too?
It says that they observed a plastic bag containing the green leafy substance. Yes, Your Honor. And that was after the passenger exited. So when they walked up, they saw him with his hand in between the console and the front seat, where they observed him trying to conceal something.
So, Judge, in the DIMS, it says, quote, as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance. The way I'm reading that, Judge, is that's more attributable to the passenger and the alleged marijuana that was near his person than it was my client. Again, the rummaging around, Judge, I don't think there's enough of a nexus to establish that. My client yielded to law enforcement show of authority. He gave law enforcement his ID. While he's standing there submitting to law enforcement show of authority, the guy with his hands up with the marijuana that's around him leaves. So if anything, this should be attributable to the passenger.
Saying that the weed is the passenger's client, not your client. That's what you're saying.
Yes, and based on the allegations, Judge, there's not enough probable cause that attributes my client knew or intended that marijuana was in his possession when everything just as much points to someone who ran away from the cops.
Read the DIMS again, and then who is the one who's allegedly hiding things? Is it?
And right here, watch the judge walk him right into his own argument. Beautiful.
It's the driver, Your Honor, which is the defendant.
Right.
The officer said the officer observed the driver have his hand between the front seat and the center console, and previously...
Okay, wait. So between the front seat
in the center console, and the officer said, I observed the driver leaning over the console trying to conceal something next to the console and front seat passenger. And that's where he observed his hand in the front seat, between the front seat passenger and the console. So the officer observed him trying to conceal something. And all the DIM says in regard to the passenger and the marijuana is that as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance smelling of marijuana. It doesn't say anything in regard to it being solely in the passenger's area, because it said previously he was trying to conceal something.
Again,
So
My apologies, counsel. Judge, if I may.
He's actively trying to conceal a plastic bag.
Your Honor, so with this situation, when we were briefly speaking,
give you
allegedly
a
this
second.
driver
Yes.
and passenger don't know each other, but then in this situation, should this person, the defendant, be pulled over for speeding, one would think he'd keep his hands 10 and 2 and not be trying to conceal something, so that's where we're at. And if you didn't know that didn't know the passenger, didn't know that they had the marijuana, didn't know anything about the marijuana, why are you concealing? Why aren't you keeping your hands at 10 and 2?
Judge, anytime somebody's driving, again, I think there's a reasonable inference that goes just as much to my client was trying to go through his belongings, give law enforcement the correct identification so that he could submit to law enforcement show of authority. Again, just because it says concealed doesn't mean that there's enough allegations that actually substantiate that anything was concealed. If anything,
No, but is that enough for him to continue and to investigate further? Right, his allegation is, I come up to the car and I actively see someone trying to conceal something. So at that point, I'm going to investigate further.
my issue is not, law enforcement had the right to further investigate the case. We understand that my client was speeding, Judge. My issue, though, is that they're saying that the front seat passenger is getting out of the vehicle and then he sees weed as the front seat passenger gets out. My client is already.
So who do they both have weed? Is that what happened here? Do they both end up with?
My understanding, Judge, is that there's enough probable cause that actually goes toward the passenger being in possession of the
Did
weed.
they find weed where he was trying to conceal whatever he was trying to allegedly conceal?
The allegations are not clear about that, Judge, which is why.
Admittedly, they are not clear about that because all it says is that as the front seat passenger exited, they observed the plastic bags. But for previously, they did say.
Where?
It does not say, Your Honor.
That sucks. Then write a better report.
It does, but they did say
You
that
know?
someone concealing something between the console.
I need to know, where is the weed in the front seat passenger?
All right, there are enough affirmative links still because he's the operator of the vehicle and is within his wingspan, and they saw the previous furtive movements being made to draw the inference of knowledge. So there's enough affirmative links between him and the contraband for probable cause.
I don't work on hunches.
It's not a hunch.
Hunches here. I mean, it's not that hard to write in the report. Well, I saw weed where I found his furtive movements. You know?
Yes, Your Honor, they didn't clarify that, but they did see him
Then
concealing.
too bad, so sad.
Judge said too bad and meant every syllable.
Sorry.
I will say, Your Honor, this did just happen 2 days ago. If we could wait to get the offense report, maybe he articulated it
No,
more.
I mean, I he's in custody. I don't want to wait 2 days because he's in custody. If he was on bond, perhaps, but he's in custody. He's in jail just sitting there, you know? I'm with you. Okay.
Thank you, Judge Fleisher.
We're gonna.
Yeah. I mean, hey, Alex, I'm not asking for much, just a little clarity. That's it, you know? And I bet you now, hopefully never make that mistake again.